And welcome everyone again. We really appreciate your time joining us today. And our purpose is to provide continuous education to all the landlords in Pasadena about the Pasadena Fair and Equitable Housing Charter Amendment and its implementation. So hi, everybody. I am Philip Leclerc. I'm the Interim Executive Director for the new Pasadena Rent Stabilization Department. And we are also joined here today by Stephanie Chandler, a directing attorney for eviction protection at the Housing Rights Center. So before we get started, there are a few Zoom housekeeping items I want to share. The first is that this entire workshop will be recorded. So if you miss something or want to refer to this later and want to share with others, it will be posted online in about a week. We also want to hear from you. Our Q&A, and there's a symbol for Q&A just in the Zoom session. And there you can submit your comments or questions that will be answered by our housing counselors who are behind the scenes who will be able to answer your questions. Also, Stephanie and I will be answering your questions live at the end of our presentation. And also at the conclusion of our workshop, there will be a survey that will be available. We kindly ask that you fill this out. It gives us feedback on making sure that these workshops are important and useful to you. And finally, one more disclaimer. We're not here to provide legal advice, but rather to educate everyone on the Charter Amendment and its implementation. And so if you have a very specific question about your own specific situation, we really recommend that you contact one of our housing counselors or consult with an attorney. So let's get started. We have a packed agenda for you. Put the agenda up.
Philip, just sorry to interrupt. Could you launch the interpretation if it hasn't been launched already?
There we go.
Thank you.
In case if it wasn't launched already, if you could click on interpretation and select the language of your choice. So you will hear the correct stream. So back to the program. So our agenda today is pretty packed. There are some things that may be repeated from a prior landlord workshop, but there's a lot of new things as well that we want to share with all of you. And so also for those of you who are very new to the Pasadena Fair and Equitable Housing Charter Amendment, there is a deeper dive available on another workshop that was posted on October 24th of just this last year, which really gets into a lot more of the nitty-gritty about the Pasadena Fair and Equitable Housing Charter Amendment. We will do a quick overview of a lot of those topics, but a really big deeper dive, I'd refer to people to go check that out. We expect our presentation today to be about 45 to 50 minutes in total, and then we'll be open for Q&A. So in our agenda here, we just did our introductions. We'll do a very quick high-level overview of the Pasadena Fair and Equitable Housing Charter Amendment. We're going to share with you some of the accomplishments that have occurred over this last 9 months. We're going to talk about the new rent stabilization department of the city, our rental registry timeline, some new regulations that have been recently approved by the Pasadena Rental Housing Board, the petitions and hearings overview. And then we'll be moving into an overview of fair housing, as well as getting into just cause eviction details, relocation assistance, rent rollback, and then finally our Q&A. All right, so just a quick overview of the Pasadena Fair and Equitable Housing Charter Amendment. Just to remind you all that this was approved by Pasadena voters back in December of 2022. And there's two major provisions of this charter amendment to keep in mind. The first is rent control. Rent control applies to multifamily residential units that were built prior to February 1st, 1995. There are a number of exceptions, including condos and single-family homes, which are not a part of this rent control. There's also limits. Rent control has limits on annual rent increases, and the current increase available between October 1st of last year through September 30th of this year is 2.75 maximum increase. There are many more provisions of the rent control, and I'll be pointing to you for how to get more information about more details about rent control, but these are the high levels. In terms of eviction protections, that's the second part of the Pasadena Fair and Equitable Housing Charter Amendment, is there are now eviction protections that applies to nearly all residential rental units. That includes condos and single-family homes. There are a number of exceptions that apply, and you can get more information about that. We'll point to those information soon. There's also only 11 allowable just cause reasons for eviction, which we will go over later in this presentation. There's also relocation assistance that's required for no-fault evictions, which we will also go over later in this presentation. And another item in the eviction protection is a requirement for landlords to notify the rent stabilization department whenever one of the 11 allowable just cause evictions are applied to your tenants. So moving on to accomplishments since this amendment was put into place. First of all, the Pasadena Rental Housing Board was established back in April of 2023. And since then, they've been working very hard on moving this initiative forward. There's been a number of forms and guidance and handouts, particularly 11 that have been created, both in English and Spanish. There's been a number of tenant and landlord workshops. There's been 3 already, also in English and Spanish. And this is the second landlord workshop. There's been a number of policy and regulation adopted by the Rental Housing Board, over 11 pieces so far and growing. There's more to be done. There's been a number of community interactions. Our mailing list has grown to over 600 people who are interested in learning more about this and how it's being applied. We're also fielding numerous questions from the community, both landlords and tenants. We've had over 300 interactions with our housing counselors. Also, the newest information is there's been a creation of a rent stabilization department, a new department of the city of Pasadena. And some of the successes there is there's a comprehensive website that's been launched with lots of information. We're in the process of hiring a number of support staff to support the entire community. And also, we're beginning the rental registry kickoff, which we will go into in more detail. So the first start is the Rent Stabilization Department. This department was just created in December, just a little over 2 months ago, to support the Pasadena Rental Housing Board implementation of the Pasadena Fair and Equitable Housing Charter Amendment. This is very important, and this is probably one of the biggest opportunities for landlords to get much more information and clarity about this entire measure. The website is citypasadena.net/rent-stabilization. And there on the website, which was just launched at the end of last month in February, is a lot of information really organized for tenants and for landlords, and providing a huge expansive list of frequently asked questions that we've been fielding from our housing counselors and from many members of the community. The website also has some improved communications channels that help you reach housing counselors and the department staff to answer questions and make sure that you have the information that you need. Of course, there's a lot more information to be built in this website. And so this is an early version that was just released less than a month ago. If you haven't seen the website, this is just a screenshot of what it looks like. And at the top of this page is a drop down, particularly for landlords, that really highlights a lot of information that should be helpful, not only in answering many of your questions you may already have, but also direct you to the parts of the charter amendment that are relevant to the situation that you may be investigating or the things that you need to do. So I encourage everyone to visit the new Rent Stabilization Department website and also to subscribe to the mailing list to provide more information as things are released. Also on the department website, you'll find information about how the department is being built up to support the community, tenants, and landlords' needs. This is just an overview. This exact one is available on the website, and it really talks about 4 major pillars of the things that are happening over the next 6 months in helping build out the rent stabilization department. We're busy hiring support staff. We're building an office. We're beginning to implement the rental registry database. We're helping conduct webinars such as tonight. And also we're supporting the board with new policy and also with other administrative functions. So the next topic is the rental registry. Some of you may know what that's been about, but some of you may not. But what is the rental registry? This is a central database of rental units, all residential rental units, that will be put into this database, which will include property information, rental information, and ownership information. And what's really important about the rental registry is this is the database that will contain all the information about renters in our city, according to property. And at some time in the future, within the next few months, we will be talking more about the rental registry and how landlords, yourselves, will be inputting information about every rental unit under your management into the system that will be used to implement the various provisions of the Charter Amendment. The tentative rollout schedule has already begun. We have done a kickoff meeting already with the software vendor that will be supporting this initiative. Coming up in April, there will be some stakeholder engagement meetings to get some feedback. In May, we'll be developing the system and the related regulations. We'll be piloting the system in June. And then by late June, early July we'll be opening up registration. And from summer through the fall of 2024, there will be landlord registration workshops and various outreach to help you connect with the rental registry and input the information that's required. This is a tentative rollout schedule. We're still working with our software vendors and all the information that we need to put into the system. But this is generally the time frame where this will occur, and we will provide more exact timeline soon. This is another opportunity for getting more information out to you. If you sign up to the mailing list, we will be able to provide you more updates more timely. Petitions and hearings. In January of this year, the last piece of regulations that the Rental Housing Board adopted was petitions and hearings regulations. And what are petitions, particularly, is that they are the requests for rent adjustments that are above the annual general adjustment. So this only pertains to rental units subject to rent control. And if you remember the Charter Amendment, rent control only applies to rental units that were built prior to February 1st, 1995, as well as some other exemptions. And so petitions are important because there are reasons for landlords as well as tenants who would be looking for a rent reduction. Landlords were likely looking for a rent increase that is beyond the annual general adjustment. And these petitions will be available around summer of 2024. And the petition process is tied to the launch of the rental registry. And that the plan is approximately 30 days after the launch of the rental registry, the petition process will open and landlords will be able to file for upward rent adjustments, which will be reviewed by hearing officers that will conduct the review of those adjustments and render decisions on those petitions. So what can you do in the meantime to prepare for the opening of petitions? You should be gathering documentation and keeping records so that you'll be able to pull together the information that will be needed as a part of the petitions. Some examples of things that you may want to begin compiling if you're preparing to do a petition this summer could be income and expense summaries, for sure, descriptions and documentations of unavoidable increases or decreases in maintenance costs, other planned or completed capital improvements. Potentially, there's substantial deterioration that also should be captured in pictures and in documentation, and any other additional explanation that you believe would be important for justification. So I provide this information now just to think about the kinds of things that you'll need to be prepared for when the petition process is open. So this was a mouthful already, but I want to change gears and hand over the presentation to Stephanie Chandler, who will be from our Housing Rights Center, who will be providing some more information, a part of our agenda. Stephanie.
Wonderful. Thank you so much, Philip, and good evening, everybody. As Philip stated, I work at the Housing Rights Center, which is the nation's largest nonprofit organization dedicated to securing and promoting fair housing. And part of what we do in order to further that effort is to provide free and confidential housing counseling for both landlords and tenants. The goal with this is to provide better understanding of your rights and responsibilities and connect with community resources as applicable as well. I have on the screen here is the contact information to contact our housing team at the 1-800 number, also by email at info@housingrightcenter.org. And we also have 2 locations in the city of Pasadena where we provide walk-in services as well. So you don't have to call or email, you could walk right in to speak with a housing counselor. And those are located at 1015 North Lake Avenue in Suite 100. And then we also have an office at the Jackie Robinson Center as well. And I apologize, it might be cut off a little bit on the screen, but the third location listed is our main office, which is in Koreatown at 3255 Wilshire Boulevard, Suite 1150, 1150 in Los Angeles. And next slide, please. So one reason I think this is the large part of the work that we do is the counseling questions is just because there's a lot of laws that pertain to both landlords and tenants, their rights and responsibilities from multiple different sources, including federal law, state law, and of course, local law, right? So here in the city of Pasadena. And in the context of the questions that we get a few different, we've been noticing a few different subject areas, and so that's what I'm covering today. And the first one of those is fair housing. So fair housing laws primarily stem from federal and state law under the U.S. Fair Housing Act and the California Fair Housing and Employment Act. And this applies to housing transactions for residential dwellings. So that would include renting both to prospective and current residents, any type of dwelling unit, so apartments, condos, houses, duplexes, residential motels, etc. Next slide, please. So within the fair housing laws, they have created protected classes. Under both federal and state law, protected classes are color, disability, familial status, national origin, race, religion, and sex, which includes gender identity and sexual orientation. And under state law, additional protected classes are ancestry, gender identity and expression, marital status, medical condition, military or veteran status, sexual orientation, and source of income. Next slide, please. And within this, in addition, under those laws, there's specific prohibited practices, right? So, and these would be actions that are prohibited to take against someone because they belong to one of those protected classes. So that would be, for example, refusing to sell or rent housing, saying that housing is unavailable when it actually is, setting forth different terms or rules for someone based off of them belonging to a protected class, discriminatory statements or advertising, steering, for example, like suggesting to someone, oh, well, wouldn't you prefer a neighborhood with more kids in it? Something like that. Threats, intimidation, harassment, retaliation, denying a reasonable accommodation or modification, or otherwise making housing unavailable. So I'd like to take a closer look at 2 of the protected classes. The first one being source of income. Next slide, please. So source of income basically refers to all lawful sources of income. right? So we're familiar with, I think most are familiar with, right, getting income through wages, right, through employment. But that source of income also applies to public benefits such as Section 8, SSI, et cetera. Non-work income like child support or alimony, as well as other types of assistance that might be available through rapid rehousing, homelessness prevention, security deposit assistance, and programs such as that. So examples of to address our first requiring a credit check of applicants examples of prohibited behavior, right, would be requiring a credit check of applicants who use a government rent subsidy, refusing to accept or approve applications from tenants because they receive a Section 8 voucher, refusing to accept a Section 8 voucher from a current tenant, right? So maybe they started receiving a voucher after they had moved in, or otherwise applying different terms or criteria, right? Such as charging higher rent, requiring a higher credit score, et cetera. And then lastly, just also want to be mindful that you're applying income standards correctly. They have, so if you're for example, requiring 3 times rent, that must be applied to a tenant's portion of the rent only. So if they're getting a subsidy, you don't calculate off the full rent, you calculate it off the tenant's portion. And on the next slide, I was going to go over in more detail the new law that passed regarding the credit check requirement. So this was passed under a Senate Bill 267 and applies to tenants who receive government rent subsidies. Under this law, a landlord must give applicants the option to provide alternative evidence in place of their credit score when applying for a rental unit in order to show that they can cover their rent payment each month. So some examples of alternative evidence would be proof of benefit payments, pay stubs, or bank statements. In addition, landlords must also allow a reasonable time for an applicant to gather their evidence. And this law went into effect on the 1st of this year. Next slide, please. All right, and then the next protected class I want to take a closer look at this evening is with respect to disability. So disability is defined by the impact on the individual person. And it basically means a sort of any physical or mental impairment which limits any major life activity, such as seeing, hearing, walking, breathing, etc. And some examples include visual, speech, or hearing impairments, cerebral palsy, autism, cancer, heart disease, HIV or related conditions, mental or emotional illness, drug addiction, alcoholism, or even COVID-19. Next slide, please. So one of the prohibited activities I had mentioned on the earlier slide was refusing to allow reasonable accommodation or modification. So I just wanted to speak for a moment on what those are. So tenants or applicants with disabilities can request accommodations, which are exceptions to rules or changes to services, or they could also request structural modifications related to their disability. And the purpose of allowing these is to ensure tenants with disabilities can get equal use and enjoyment out of their housing. So some examples of accommodations might be changing when the rent due date is. So for example, if it's normally due the 1st, perhaps the tenant needs it to be due like on the 15th, for example, and just in order to coincide with when when their benefits are distributed. Allowing a service or support animal when there's otherwise a no pets policy. Change it like, something related to parking space, maybe location, or allowing an extra one, transferring units, allowing a living caregiver, ending the lease early, extending time to vacate. Right, so these differ, right, from modifications where you're actually physically changing the space, such as installing a wheelchair ramp, grab bars, lowered countertops, or visual doorbell. Tenants are typically responsible for the cost of implementing the modifications, and often typically also need to restore the unit to their original space upon move out as well. Next slide, please. And then in evaluating whether or not to grant reasonable accommodation or modification, we look to whether it is necessary and reasonable, right? So if it's necessary, that means it's directly related to the impacts of the person's disability and either improves their living situation or enables them to live there at all. And I just also wanted to note, if a disability is not readily apparent, the landlord can request verification that the request being made is necessary. And that verification can be provided by any independent, reliable third party. And I think the most common example might be a physician. And then in addition to being necessary, it also has to be reasonable, right? So the request cannot create an undue burden or fundamentally alter the business of the landlord. And if a landlord cannot reasonably fulfill the request, they must engage in a good faith dialogue to find an alternative. Next slide, please. All right. Next, moving on to more local law under Measure H, talking about the just cause protections for eviction. So as Philip stated earlier, under Measure H, the just cause protections for eviction apply to the majority of residential tenancies in the city of Pasadena, including condos and single-family homes. If you want to read the full definition of what is exempt or what's covered, you can go to Measure H, Section 1804, or if you go to the new rent control and eviction laws guidance form, that also has a good, more detailed overview. But what does just cause mean? So just cause essentially means that a landlord may only evict a tenant for a specific reason, and those reasons that are allowed are stated within the charter, within the language of Measure H. Each reason has specific requirements and or prerequisites. So, if you're in a situation where you need to give a tenant a notice to terminate tenancy, I recommend looking at the language of Measure H just to make sure that you've fulfilled all those requirements and are giving the proper notice in that way. Just because if the requirements are not met, it arguably means that the notice is not valid, which essentially means it's not terminating the tenancy. So you just want to be mindful of that. Next slide, please. So the actual reasons that are allowed are on the screen here. There's 11 different reasons, and they can be grouped into two categories, those being at-fault reasons and no-fault reasons. So at-fault reasons are where the tenant did or did not do something that they were supposed to do or not supposed to do. So most common example, of course, is not paying the rent. Other reasons include a breach of lease terms, creating nuisance or substantial damage, using the property for an illegal purpose, refusing to renew a new lease with the same terms, denying entry after getting a valid notice, written notice, or at the end of the tenancy, that having a subtenant is in sole possession of the unit at the end of the lease term. No fault reasons are listed on the right side of the screen and include necessary and substantial repairs. Ellis Act eviction, so this is removing the entire building from the rental market. You need to vacate the property in order to comply with a government order, or for owner move-in, which also includes owner family members as well. And I just wanted to highlight here for no fault reasons, that doesn't mean no reason. So if you're going to terminate the tenancy, it has to be one of these listed reasons on the screen here. And then again, you can read more detail about that under Measure H, Section 1806, subparagraph A, and these are listed underneath that from paragraphs 1 through 11. Next slide, please. So as I mentioned, each of these reasons have varying requirements and some have prerequisites. But overall, these are kind of the shared notice requirements amongst all of these, right? So the notice, for example, must state grounds for eviction alleged compliance with the charter amendment, and the landlord must file the notice with the rent board within 3 days of serving the notice to the tenant. There is a form summarizing protections that needs to accompany the notice, which is available on the Rent Stabilization Department website. And again, as noted, right, if you don't comply with the terms, the notice is arguably invalid, which can be raised as an affirmative defense to an eviction action should the situation proceed to an unlawful detainer. And the other thing to note as well is that if the reason for terminating tenancy is a no-fault just cause reason, then there is going to be relocation assistance required, which actually brings me to the next topic. Can you go to the next slide, please? Let me grab some water. Second. Thank you. All right. So relocation assistance itself is financial assistance that's required when a tenancy is terminated for a no-fault reason, or under Measure H, right? If the tenancy is ending due to a large rent increase that exceeds 5% plus the the AGA amount, right? So the 2.75% for this year. So I just also wanted to note other requirements might apply in these scenarios, such as a right of first return, providing full refund of the security deposit, providing services for a relocation specialist as well. For more detail on relocation assistance and these other requirements, you can read about it under the Housing Board Resolution 2023-10. But for this evening's purposes, I'm going to focus on relocation assistance, the financial assistance. Next slide, please. All right, so again, there's kind of two larger categories into which relocation assistance might come into play, where if the landlord terminates the tenancy for a no fault just cause reason, which again are necessary and substantial repairs, owner move-in, withdrawal of the unit, excuse me, the building, including the unit permanently from the rental market, or in order to comply with government order, or if the tenant needs to terminate their tenancy because of their inability to pay a legal rent increase, which exceeds 5% plus the AGA. So just to note, in order for that rent increase to be legal, that means the unit is not covered under the rent stabilization portion of Measure H. We just wanted to, you just want to be mindful about it. If the unit is covered by rent stabilization, then you're not, the rent increase is limited to the AGA amount. Next slide, please. Right. So the timeline for providing the relocation assistance payment is laid out in Measure H. So if the landlord is terminating the tenancy for a no fault just cause reason, at least half of the relocation assistance must be paid to the tenant within 10 days of service of the notice to terminate their tenancy. And then the remainder must be paid no later than 28 days before the expiration of the notice to terminate tenancy. So this means the tenant has received all of the relocation assistance at least 28 days before they're supposed to move out. In a situation where the tenant is terminating the tenancy because of a large rent increase, at least 50% must be paid to the landlord, by the landlord to the tenant within 10 days after the board has basically confirmed the amount of relocation assistance that is due. And then the remainder must be paid to the tenant upon leaving the rental unit. Next slide, please. So here is a chart that's detailing the overall calculations for relocation assistance. There is actually a worksheet that's on the rental board website that goes into more detail, but what I really want to highlight here is that the amount of relocation assistance is going to vary depending on a few different factors. First being the size of the unit, right? So it's going to vary depending on whether it's a studio or how many bedrooms it has. And then it's also going to vary depending on the length of the tenancy. If it's under 3 years, 3 to 10 years, or over 10 years, right? There's going to be different amount of relocation assistance based off of that. And then in addition to that, there may be additional payments required if for special circumstances households. So factors that would qualify a household as being special circumstances for purposes of relocation assistance are if there's somebody living in the unit who is 60 years of age or older, qualifies as disabled, qualifies as terminally ill, or has a child 19 years old or younger who's a legal dependent living in the household as well. In addition, there's also moving expenses that would be paid out as well. So the moving expenses would be added to the base payment, essentially. Next slide, please. And then here's just a screenshot of where you can find the tenant relocation assistance form on the website. So it's under the notices forms resource under the guidance tab. And then what I've highlighted in red here is just the title of the form. And then on the right, you just click that icon in order to take you to the form itself so you can take a look at it. And the form that's included here is basically a way for the tenant to provide any sort of kind of a cover sheet to work that tenants can use to provide any sort of documentation to help communicate whether or not they qualify as a special circumstances household, and basically calculate the total amount of relocation assistance that would be required under Measure H. All right, next slide, please. All right, and then lastly, I just wanted to speak about relocation assistance. Not relocation, excuse me, rent stabilization. So rent stabilization is another larger portion of Measure H, and it applies essentially to multifamily residential units that were built before February 1st, 1995. Just wanted to note that tenants who receive Section 8 vouchers are not exempt from rent stabilization. We're going to go off of base of what the unit. And on the website, there's a guidance form that talks more about this point as well. But effectively, what rent stabilization does, right, it required everybody to roll back the rent to a base rent amount. And then it limits, it sets kind of guidance uniform guidance in terms of allowable rent increases that can be given each year thereafter. So base rent is either the rent that was in effect on May 17th of 2021, or if the tenancy started after that date, then the base rent would be the amount that was in place at the start of the tenancy. And then the annual allowable rent increase amount is calculated based off of the percent change in cost of living. So it's 75% of the change in cost of living. Currently, the allowable rent increase is 2.75%. That applies to any rent increase that goes into effect by September 30th of this year. You can, increase the rent at any point in time. It doesn't have to be by on September 30th, or it doesn't have to be October 1st. However, just note that it's not banked. So if you didn't increase somebody's rent for whatever reason this year, whatever the new AGA is for next year, let's say, for example, it's 3%, you can't increase the rent 5.75%. You can't bank it, right? It's basically, if you don't increase it when it's in effect, that's kind of, you lost the chance to do that. I did also want to note that, there are limits in terms of when you can increase rent. So they are not allowed if there are severe code violations, not allowed if there's an order of the board stating that, or if you're in non-compliance with the article, which includes a failure to roll back the rent to the base rent. And it's probably just cut off a little bit at the bottom of the screen here, but rent increases are also limited to once every 12 months. So if you've increased the rent within the last 12 months, you have to wait before you can increase it again. Next slide, please. Now the rent rollback process, in order to try and simplify it, I guess, in a way, right? There is the board has established a sort of rent rollback process that allows a tenant to initiate the process to withhold the rent in order to correct overpayments. And this is just, even it is the landlord's responsibility to take this action, but of course, right, the tenant has one unit to be concerned about, whereas landlords, you have multiple units to, go over all this information with. So by having this process, it allows the tenant to initiate that. And so there's basically two main steps to the process. So first is the tenant would complete a form that's called the request for rent rollback. On that form, they would lay out, what their base rent is, what they've been paying, and then basically it walks them through how to calculate basically the amount of their overpayment, and then how much they would need to withhold basically based off of that. And then the second form would be a written notice of rent withholding. So that's basically the precursor form before the tenant actually takes the step of withholding rent. So if you get that form from the tenant and that you have any disagreement, or you don't think that their information is correct, but they put when they've requested the rent rollback, they have to, you have 10 days to respond. So that way you can work out together and figure out where the discrepancies are coming from. But thereafter, if there is no response, if you agree, you can either let them know or just not respond. And then from there, the tenant can submit the written notice of rent withholding form to you. And then 5 days after that, they can give it to their rental housing board, and then begin withholding rent. And again, it's withholding rent only to the extent that it is correcting the amount of overpayment. And so within that, on the form, it actually lays out which months they're going to be withholding and how much each month. And then essentially when that will be ending as well. So if the tenant does follow those procedures, and if there is a unlawful detainer for non-payment brought against them, they can present this as does provide them with an affirmative defense if they follow the steps properly. So just wanted to make sure we go over that today. And again, just to reiterate, right, this is a good way to let the, it's an important process to go through, just again, because if the rent hasn't been rolled back to the base rent amount at all, then you can't increase the rent with the tenant moving forward either, right? So this is, again, that kind of that first step to be able to basically be in compliance with this rent stabilization portion of Measure H. Right, next slide, please. Great. And then we just have linked here are just a few different additional resources. A link to, I think, the charter amendment itself. So that's section 8, excuse me, measure H. And then also to the rent stabilization department's website. Underneath there, the eviction protections overview. That's a really helpful page that's available under the drop-down menu for landlords and also for tenants. But it provides a good high-level overview for many of the topics we discussed today, as well as links to more detailed information.
Okay. Well, we are at the end of the formal presentation, and we can see that there's been a lot of questions and answers that have been going on behind the scenes. And but we are both available, Stephanie and myself, to answer some additional questions for the audience. Stephanie, have you a chance to look through the Q&A?
No, I didn't have it up when I was speaking, so I'm just taking a look and just getting caught up.
Greetings, everyone. While Stephanie and Philip are looking through the questions, I just wanted to note, first of all, Allison Henry, at-large member of the Pasadena Rental Housing Board. Thank you, everyone, for joining us tonight. Thank you for the questions. I have put in the chat various parts of the city's rent stabilization website, relatively new. And I've tried to put in, as the conversation was moving forward, items like forms and previous workshops and presentations. This workshop will be uploaded, if not late tonight, tomorrow, up to the website, the rent stabilization website. So you'll have the resources there. I hope that's enough time, Philip and Stephanie, for you to review the Q&A and to hit anything that you need to hit. And thank you again, property managers and landlords of Pasadena, for coming, and community members for coming tonight. You're key to this working. So thank you very much.
Great.
Okay, so one question that was asked was just essentially clarifying for units that are not covered under rent control, how much can a landlord increase the rent? It would depend. I think in the example they specified a condo, but you just want to be mindful to make sure that it's not covered under state law, which is the Tenant Protection Act, which caps rent increases at the lesser of either 10% or 5% plus the change in cost of living. So currently for LA County, that would be 8.8%. But typically, a lot of situations, condos might not be covered under the Tenant Protection Act. So you could increase it more. If it's over 10%, there often might be different notice requirements. You may have to give a longer time frame. However, just note that if the increase that you put into effect, even though it's legal, if it's 5%, but if it exceeds 5% plus, basically if it exceeds at this point 7.75%, right? That 5% plus the AGA amount, and the tenant can't afford that, they do have the option to terminate the tenancy. They have to notify you of that, but then that would trigger that relocation assistance payment situation. So just wanted to note that.
And here's a question. We did go through rent rollback, but the question is, when is a rent rollback used?
So it should be used. I mean, it should have. It only needs to happen once, essentially. Once you've rolled back the rent, you don't have to worry about it any longer for that unit. It should have gone that portion of Measure H went into effect in December of 22. So it really should have happened starting January of last year. So if you haven't rolled back somebody's rent and they've been a tenant before then, right, then they might have quite a bit of rent to roll back, depending on how much rent has increased since the May of 2021. But if it's like a new tenancy, somebody starting it, moving in next month, for example, right, that's not really an issue because, you're starting with a new tenancy.
Here's a question. Do we have to register if we only rent the back house? I'm assuming this refers to when the rental registry is up and running. The rental registry, remember there's two sides of the charter amendment. And so almost every rental unit in the city, there are some exceptions, but almost all of them are subject to eviction protection. And those eviction protections require those rental units to be registered. So on the simplistic information that I have here, any residential unit, just about any rental registry will need to be registered.
I just see a couple other questions related to like rent rollback and rent increases. So one question was just regarding whether if landlords owe a tenant credit for any overpayments they made after the rent is rolled back. And the answer is yes, you'd either need to refund them or just credit it towards their next month's rent, essentially. And that would take care of that. Another question was asking if there was no rent increase established for 2022 and 2023. There was rent increases established. I didn't cover the first rent increase because that time has ended, and we're allowed to bank it. But essentially, the first rent increase that would have been allowed to go into effect after rolling back rent would have been up to 6%. The amount would vary depending on when the tenancy originally started, right? So the longer the tenancy was, the higher the rent amount, the higher the rent increase that was allowed, up to 6%. And then for rent increases that went into effect beginning October 1st of last year, that's 2.75%. And that amount is in effect through September of this year. And the board will announce a new rent increase for next year, I believe by September of this year, in order, with enough time essentially, so that way you could give notices if you're going to implement a rent increase effective October 1st. So essentially the window is like October through September of each year.
There's a question here about where can I find information on ADU rent rolls? And I'm assuming the ADU rent rules are referring to maybe rent control. And so if the ADU was built prior to February 1st, 1995, then it would be covered by the rent control measure. A lot of ADUs in the city have been built over the last couple of years. And so if that's the case, if it's an ADU built, let's say the last year or two, it does not apply. Rent control does not apply. However, the eviction protections would still apply for every residential, just about every other residential unit. Another question here, are all apartments built after 1995 covered under the eviction protections? The answer is yes. Almost all rental units, including condos and single-family homes, are covered under eviction protections in the city of Pasadena.
And also just got a clarification question based off one of my earlier answers regarding the LA County rent increase. So the LA County rent, it's not the LA County rent increase, rather it's the state, like the Tenant Protection Act, that's a state law. That rent increase is based off of the cost of living within the county. So for LA County, it's 8.8%. However, within the city of Pasadena, if you implement an 8.8% rent increase to a unit, that amount, right, it's higher than 5% plus the current AGA, which comes to 7.75%. That would trigger the option for the tenant, if they can't afford that rent increase, to notify their landlord that they need to terminate their tenancy because of the rent increase, and then they would be entitled to relocation assistance. It looks like there might be some questions about or when to be notified, if they'll be notified regarding when to register for the rent registry, if the mailing list will be notified, excuse me.
There was a question about what are the requirements for the rental registry? And the requirements are still being ironed out. There will be some configuration, and I apologize, I don't have all the answers there for you. But most of the information for landlords, from what I know, is about the property information. So the parcel, number of rental units that are on the parcel. If it's under rent control, it would also include what the current rent is. It would have some basic information about the tenancy. For instance, when did the lease start? And part of the benefits of the rental registry for landlords is that for those under rent control, it will help streamline rent increase calculations and compliance with the measure. Also, there'll be easier tracking capabilities of improvements that have been done, like capital improvements, changes on the property. And it also ensure kind of better communications with the rent stabilization department once that is up, because that will be our primary source of communications between landlords and the rent stabilization department. But more information about the rental registry will come, and we'll have many more workshops about this topic to prepare everyone to make it as easy and seamless as possible to register.
Thank you. Wait, so I got another question to clarify my prior answer, so I just want to apologize. So the 2.75% rent so the question was basically just to clarify what the max increases allowed in Pasadena, and that amount is going to vary depending upon whether or not the unit is covered under rent stabilization, right? So a quick way to weed things out is depending on when the unit was built. So if it was built before February 1st, 1995, it very likely falls under rent stabilization, in which case you cannot increase rent this year through September of this year beyond 2.75%. That's the limit in place right now. However, right, there's newly built units, right? Things that might have been built after that. That 1995 date comes from a state law called the Costa-Hawkins Act. So it's kind of set in stone. It's not something that the city can change at this point. So for units that aren't covered under rent stabilization, you would just need to look just to make sure you're in compliance with any other applicable laws, which could also include the Tenant Protection Act, which is what I was mentioning before. So those allow for rent increases that could be much higher, right? Could be 10% potentially, or whatnot. However, under relocation assistance rules, right, if the rent increase exceeds 5% plus the set AGA amount, that's what would trigger the option for the tenant to say, like, I can't afford this, I need to move out, and so on and so forth. So that's the difference. So the max increase in Pasadena each year it's not uniform for all residential tenants. It's really going to depend on what law applies. So first you want to basically look to whether or not Measure H rent stabilization applies. And if so, you're done, you know what the limit is. If not, then you want to look to if you're within the incorporated areas of the city of Pasadena, then you just want to look to whether the state law applies, the Tenant Protection Act. If you're I know there's some unincorporated areas nearby, so then in that case, you might want to double check just to make sure the unit's not covered by LA County unincorporated rent stabilization, and then state law. So if you have more questions about it, I would really just recommend maybe talking with the housing counselor, either with the rental housing board or the housing rights center. Because we would be able to look more specifically at like your unit or your building that you have a question about and provide a little bit more guidance in that respect.
Right, a quick question here, just someone asking to repeat who or which rental units need to be registered. In referring to the rental registry that will be coming online June, July, nearly all rental units in the city will need to be registered. There are some exceptions, which are enumerated on the FAQs on the Rent Stabilization Department website. But because there's two sides of the charter amendment, as Stephanie mentioned, there's the rent stabilization or rent control, and there's also the eviction protections. Since it covers nearly all rental units, including condos and single families, they will all be required to register. And then the second question I have here is, what are petitions for? Just to repeat. So the petition regulations that I mentioned earlier, this is the tool for landlords to who have units that are under rent control, so older than February 1st, 1995. The petition process is a petition for landlords to increase the rent above the annual general adjustment, which this year the AGA is 2.75% through September 30th. So if you had a situation, a big capital investment or some circumstance that would warrant an increase beyond that 2.75, a landlord would collect the required documentation to substantiate that, and they would file a petition for an upward adjustment, and that would be reviewed by a hearing officer for a determination. And those petitions will be available this summer, approximately 30 days after the launch of the rental registry. Question: if a petition is successful in the future, what is the max increase? Don't have an answer to that. I think it's all justifiable based off of what is presented and what is agreed to. There isn't anything in the regulations that I'm aware of that limit what a potential petition could be. The question: do amendments to Measure H require a vote from the citizens to be included in rent control, or can the housing board mandate? This is a nuanced question. There are enumerated responsibilities or duties that the rental housing board has, and they're enumerated in the charter. Most of the responsibilities that they have to regulate are really about a lot of the mechanisms and functions of how some certain things are implemented. But there's only 21 specific things that the rental board can do. But part of the question, I think, is looking beyond the rental board, looking at maybe some bigger things about the charter itself. And if any change to the charter language, that has to be done by the vote of the people. Just like the charter amendment was voted in December 2022, it was done by a vote of the majority of the Pasadena voters. The entire language of the charter amendment, it is quite dense. It can be difficult to consume. It is available. There are links on the Pasadena Rental Housing Board website, as well as the Rent Stabilization Department website, where you can click into the exact verbiage that was approved by voters.
Looks like there's one question that says in the presentation, it said a landlord can choose not to renew a lease agreement. Is that correct? That's not correct. One of the reasons for that a landlord may terminate a tenancy is if a tenant refuses to sign a lease agreement that has the same terms, right? So that's I just wanted to clarify that. That's the distinction.
There's a question about rent rollback. Do we owe tenants a credit for the overpayment they made after the rent is rolled back?
Yeah, so anytime if a tenant has overpaid rent at any point, right, that's paying you more than they owe, so it should either be refunded or credited accordingly. One question is asking if an increase is done in writing, but that writing is emailed. Is that in effect? No, that is not proper service for a rent increase. It has to be printed or like on paper and then hand delivered or posted and mailed. Yes, I said posted and mailed is correct. If you're not handing it in person, you would need to post it and mail it. So by posting, I realize would be like literally posting it on the door.
There's a rent rollback kind of question. I think I'm reading into a little bit. It's is there credit due for only 2023 overpayments? And the answer for rent rollback is that rent rollback goes back to the beginning of when they to May 2021. So depending on when the tenant actually moved in, the rent rollback gets calculated back to May 2021 or the earlier date. And there's a schedule about what allowable increases are available. It's definitely mentioned before. There's a nice chart that's on the Rent Stabilization Department website to refer to if you need to take a look at that. Here's a question, Stephanie, maybe you can answer. The lease I have with my tenant expired. And so now it's a month to month.
Mhm.
Shouldn't the tenant leave without any relocation assistance?
No, they still have a in-place tenancy, although it's month to month, that just essentially. It doesn't mean it's ended. It just means it's continuing on a month by month basis, which means the tenant could give you a 1 month notice to move out. If you want to lock them in for longer, right, that's where you could ask them to sign a lease with the same terms, if they'd be willing to do that. But right, if the just cause protections apply, right, as a landlord, you can only terminate the tenancy for one of the listed reasons. The lease transitioning from a year, ending from a year lease transitioning to month is not one of the listed reasons.
And also just to add, don't forget the rent relocation assistance is only for the no fault just causes, which there are 4 of.
Mm-hmm. So it looks like there was a question just to a couple of questions kind of clarifying what is qualified under just cause. So we said nearly all units are. The ones that are exempt are under section 1804 of Measure H, paragraph A. So those are basically ones that are fully exempt. So that would basically, if if they're rental units in hotels, motels, inns, tourist homes, basically anything where they've been occupied for fewer than 30 days, then just cause does not apply. Same thing goes for like rental units in any like hospital, convent, monastery, extended medical care facility, dormitory, something like that. And then also some certain government owned rental units. And then there's also a special exemption if it's a certain type of owner occupied unit. So for example, if the owner is a primary resident of a single family home and they've created a temporary tenancy, which is a specific, would require a specific type of rental agreement. Or if the tenant shares a bathroom or kitchen with the homeowner. And if, in their, so those would be exempt from just cause. But again, just would encourage you to look at the code, look at the resources on the website for more detailed information.
There are a couple questions on security deposits. Maybe Allison, you know the answer. Does interest need to be paid on security deposits?
Yes, and I saw this question earlier. So security deposits, this is not yet in effect. The board did draw up regulations around the percentage of the percentage yield. I'm not a banker, so forgive me if my lexicon's not 100% correct, but basically the annual interest rate that one would get from the charter is very specific about the number of banks. And in 2023, and I know there are people on this call who will remember this meeting and would appreciate in a positive way if you could remind us or direct us to, and I will do this in a few minutes. We did draw up some percentages. This does not go into effect until I think later this year, because I also saw a question about where do you deposit this money. And there isn't a prescription about the banks per se. It's more about the rate, how that rate is calculated, and when that rate is revisited every year. But again, that regulation's coming into effect later this year. I will continue to put information in the chat. Everyone who signed up for this meeting is on our information list. So as we update regulations, if you're not attending the board meetings, we will be updating you in some productive fashion anyway. But thank you for the question.
I answered this question before, but quickly, what's the amount I can raise rent if the building was built after 1995?
So again, that's going to vary depending on what law applies. You still need to consider whether or not it's covered under the statewide law, the Tenant Protection Act of 2019. So if it does fall under it's also referred to as the TPA. So if it does fall under the TPA, currently the maximum rent increase, I think this is through August, is 8.8%. If it's not covered by that, then there's not a limit on it. However, again, if just cause protections apply, you might be triggering a situation where the tenant has a right to claim relocation assistance. So just bear that in mind. So if you want to avoid that, you could increase rent to 7.75% because that does not exceed that threshold amount. And then the tenant does not have that. It basically wouldn't be the circumstances wouldn't apply, essentially. But that would be up to you to decide.
So the question here, do commercial tenants fall under Measure H, rental registry, and rent increases? The answer to that is no. Measure H and everything we're talking about today only applies to residential units.
I'm putting in the chat the resolution that deals with security deposits. There's December when we talked about this. I'll continue to add more information on the security deposit topic, but I just wanted to let folks know I've started to find that information. Thank you for the questions.
Following up again on rental increases. Can I increase rent for condos that are built before 1995 at 7.75%? The answer is that condos are exempt from rent control. And so condos can, rents can be increased subject to the other state Tenant Protection Act and state limits. Stephanie had mentioned that somewhere between 5% and 8.8% in LA County. Is that correct?
It's currently 8, so it's either 5, it's kind of complicated. For the state law, it's either 5% plus the cost of change, the CPI for LA County, up to 10%. So it can't exceed 10% basically. And then currently for LA County, it is 8.8% because it's a 3.3% change of cost of living, so plus the 5. Yeah, you can increase it more than the 7.75%, but if you wanted to, yeah, avoid the situation I was talking about earlier, where like basically kind of triggering the potential for relocation assistance. You know, if you increase it to 7.75% right now, that wouldn't trigger it. It might be different after October, depending on what the annual gross adjustment amount is for the next period of time. So that will basically starts a new, like it'll change essentially every October.
This question they kind of answered before, but a little differently. How does relocation assistance play a factor if the lease has ended? You know, by definition, it won't be an eviction if the lease contract date has come to an end. What plays here is that it all depends if the renter won't sign a new lease. But
Right, if the, oh, sorry.
go ahead.
Oh, no, I didn't mean to jump. Right, if you presented the tenant with a new lease to sign at the end of their original lease term or any lease term, and it's a substantially similar terms, and they refuse to sign, that can be a reason for an at-fault eviction, and that wouldn't trigger relocation assistance. If you're talking about the lease just ending and then expecting the tenant to move out, they aren't required to do that. They can continue to stay on a month-to-month basis. You know, you essentially with just cause protections as a landlord, you can't, and like you have, it has to be one of the listed reasons for you to unilaterally end the lease agreement. If both parties agree or the tenant wants to terminate, they can do that. That wouldn't necessarily trigger it. So I think that's kind of, hopefully that gets to what you're asking.
Sorry, Stephanie, actually you're specifically in the charter, section 5, under the just cause, it's refusal to execute new lease. So I would direct landlords there. The tenant who had a rental housing agreement which terminated on or after the effective date of this article, et cetera, but it's number 5. This is where, you know, I'm not a lawyer because I can't remember how to do like the letters and numbers, but it's section 1806, just causes for eviction. It's number 5. So, and that will draw it specifically. If you're offering a lease with basically the same material goods, which is what it's drawn out here, it's mentioned in the charter. And seeing our time, Stephanie, I did want to just address the relocation. If you wanted me to mention anything about that,
Oh, yes, please. Yeah.
as a board member, because I'm in a different situation to Stephanie and to Philip. So I'm a board member, right? The Pasadena Rental Housing Board. Like our advice to small landlords is the following. One, keep coming to the meetings because the board can promulgate regulations, but the support for small landlords may be beyond our initial scope. That's not to say it's hopeless. What I mean is there is productivity in all of us leaning into our city council to ask for a fund for small landlords that would be consistent with our housing element, that would be consistent with our fair housing mandate as a city, but it's not necessarily for the rental board to provide that fund or to do that. But we are very interested and eager in working with all landlords and community partners in Pasadena. And if you're interested in leaning in with us and drawing up ideas, and I don't say this to start fireworks, but rather to continue to extend my small freakish hands and an olive branch, because these are policies that we would need to go to the city council with. So that's actually my unfortunate response. I wish we did have something for you, but it's not consistent with what we're able to charge for the rental registry. But again, happy to continue this conversation offline at board meetings, et cetera, with integrity. And again, I'm just very grateful to everyone who attended tonight because I know that you just want to do the best as a business owner and landlord. Thank you.
Any final thoughts, Stephanie?
I think it's just and I recognize this is very complicated, and there's a lot of differing laws to balance. So again, I just recognize, I just wanted to reiterate, right, that both HRC and the housing board are here as a resource to the full community, which includes both like landlords and tenants. So if you do have questions in terms of better understanding the law, please do reach out to our housing counselors, and we'll do our best to provide you with that clarification. And it might be a little bit easier to do more on a one-on-one once we can get into more specific, a little bit more specific details than we can in an open space like this.
And that's the same thing that applies for the rent stabilization department. We do have housing counselors who are available to answer more specific questions. I know we didn't get to all the questions tonight that has been posed. Some questions are too difficult or too specific for us to kind of answer live right now. But if you still want to engage with us, I recommend that you go to the Rent Stabilization Department website and pose your question again in to a housing counselor, and we'll see what we can do to get clarity on that answer. And there are some other topics that have come up, which I think that do need more information to all landlords. And so things around security deposits was one of them I wrote down, and there are some others. And we'll make sure that we get some answers and get those posted on our FAQ. So knowing what you need to know and what's not clear is going to help us provide more direction for not only the person asking, but for all landlords. So we want to really thank you all for spending your time with us this evening. And we hope that a lot of the information was informative and was helpful. Don't forget that when this is over, there is a survey. If you could just take right away, which will help inform us about what things we need to improve and what things we need to change to make sure that these workshops are great for all the landlords involved. Don't forget to sign up for the Rent Stabilization Department mailing list so you can get more information about everything that's going on. This recording will be available within a week or so. It'll be posted on the Rent Stabilization Department website. And so check back there. Again, I want to thank Stephanie Chandler of the Housing Rights Center for being the co-host tonight with me. And I want to thank the Rent Stabilization Department staff who are behind the scenes and the board members, thank you, Allison, who have been supporting our efforts today in this workshop. And so with that, good night, everybody.
Thank you, everybody. Good night.